Rules Committee will come to order. Thank you very much for joining us today. I note we've got a number of members of the United States Army who are here, and we want to make sure we introduce these brave young men that have joined us, and delighted that you are here at the Rules Committee. It goes without saying that the nation's attention and focus on the men and women who are warriors and fighters who have not only represented this great country so well, and who many times are in rehabilitation and trying to recover from the things which they have brought back home. We need to understand and thank them for their service. So on behalf of the committee, and I will yield here in just a second to Mr. Polis, I want to thank you for your great service very, very much. Mr. Polis?
Well, I, of course, second that. Appreciate the presence of members of our armed forces. I want to express a special appreciation to one of our staff members for whom this is their last meeting here in the Rules Committee, Don Sisson, who has worked with the Rules Committee for 10 years. I didn't realize that until today. I knew it was longer than I had been here, Mr. Chairman. But 10 years, and worked for both Republicans and Democrats on the Rules Committee. And on behalf of Ms. Slaughter and Mr. McGovern and Mr. Hastings and myself, I really want to express our great appreciation for Don Sisson's great work here at this committee, and wish him well in his future endeavors.
Absolutely. Congratulations. Sergeant Osborne and Staff Sergeant Lewis are two of the men who are here with us today. I think they're here with their wives. No? Adult supervision? Oh, we'll point up, and I got it halfway correct here. But I really do appreciate both of you taking time to be here, all four of you taking time to be here, and I appreciate it. Today, the Rules Committee will consider three important bills that aim to spur economic growth and protect jobs from overregulation. H.R. 1422, the EPA Science Advisory Board Reform Act, is the first bill. H.R. 4012, the Secret Science Reform Act, and H.R. 4795, the Promoting New Manufacturing Act, will be before the committee today. H.R. 1422 reforms the Science Advisory Board by strengthening public participation, improving the process for selecting expert advisors, and expanding transparency requirements. This bill protects American jobs by helping to ensure that important scientific advice is balanced and unbiased. H.R. 4012 requires the EPA to base its regulations on science that is available to the public and subject to independent verification. This bill simply asks the EPA to show its work before implementing regulations, sometimes regulations that cost billions of dollars and destroys jobs across our economy. Sound science is an important part of making sure that the American people know and understood how and why we do rules and regulations in Washington, D.C. H.R. 4795 promotes new manufacturing in the United States by providing for greater transparency and efficiency in obtaining permits under the Clean Air Act. The bill would help jumpstart new manufacturing projects and create great-paying jobs sooner rather than later. I want to thank Congressman Stewart from the Appropriations Committee, Chairman Schweikert, who is also here today of the Subcommittee on Environment for the Science Committee, as well as the gentleman who was a star witness from last week, Ed Whitfield from Kentucky of Energy and Commerce, Energy and Power Subcommittee. All three of these members have been pushing legislation to ensure that America's prowess in the economic arena is better able to meet the needs of our great nation. Before we call the first group up, I would once again defer to the gentleman, Mr. Polis, for any opening statement he may wish to make. Gentleman is recognized.
Well, when we got the notice, I was hoping it would be to consider immigration reform, but if we look forward to exploring instead how we can best promote the process of science and the integrity of science, and look forward to hearing from our qualified witnesses here today, and I yield back.
Thank you very much. Well, I would ask that the gentleman, Mr. Whitfield from Kentucky, Ms. McNarty from California, please come up to the table. We've got to make sure you remember that you're going to have to probably turn those microphones on. We're delighted that both of you are here. Without objection, anything you have in writing will be entered to the record. And the gentleman from Kentucky is recognized.
Well, Chairman Sessions and members of the Rules Committee, thank you very much for the opportunity to be back here today. I'm delighted to see these young men in the military. I have the privilege of representing the 101st Airborne Division and the 5th Special Forces Group at Fort Campbell, and would like to reiterate again how much we appreciate your service and what you mean for our country. So thank you very much. Mr. Chairman, I'm here today to testify on behalf of H.R. 4795, Promoting New Manufacturing Act. As we know, when EPA is particularly aggressive these days, and when they come out with new regulations, they also have a responsibility to come out with guidance so that applicants for permitting for permits and the states have a clear understanding of what is required under the new regulation. Today, we have about $135 billion announced in new manufacturing plants. It's being delayed because of confusion on new regulations when they come out. H.R. 4795 seeks to ensure that the new manufacturing facilities will be built by improving the process for obtaining air permits required under the Federal Clean Air Act. These permit applicants become subject to the new regulations when they are adopted by EPA, but frequently EPA delays the guidance so that everyone understands what is required. As an example, EPA still has not finalized its implementing regulation for its 2008 ozone standard. And next year, they're going to be coming out with new ozone standards for the nation, but they still have not finalized the implementing regulations from 2008. So this bill simply requires that if EPA issues a new or revised ambient air quality standard, the agency also must issue implementing regulations and guidance at the same time. That's all this bill does. And we've had a lot of hearings on it. We've had state EPA regulators come in and say it creates confusion, the current policy. We need this clarification when they come out with the new regulations. We've had private industry say the same thing, and that's what this bill would do. Now, concerns were raised at the full committee markup that we would prevent, by adopting this legislation, we would prevent states from going to a more stringent standard if they wanted to. And so I have an amendment that I think you all would be considering that says nothing in this legislation will be construed to limit the authority of a state, local, or tribal permitting authority to impose a more stringent emission requirement pursuant to state, local, or tribal law. So that's all this legislation does. It just says when you come out with the new regulation, you've got to also have the guidance so that the state, the permitting applicants understand what's required. And then my amendment simply says if the state like California wants to go to a more stringent standard, they would be allowed to do so. And with that, I would yield back the balance of my time.
Mr. Chairman, thank you very much. And I'm delighted to hear not only that you're here, but that you have a perfecting idea to that also. Ms. McNarty, welcome to the Rules Committee. We're delighted that you're here. You have been here, but not often. But I want you to know that your ideas and the things that you bring before this committee are very important. It's important not just to your party. It's important to a lot of people across the country. And we're delighted that you have an opportunity to come here, express yourself clearly, to make your best arguments. And I don't know the outcome of what you're going to do, but what I do know is that we're delighted that you're here. These young men have fought for our freedom and opportunity that includes your chance and Chairman Whitfield's chance to be able to come in an open environment and to be able to speak clearly about the things which will make our country strong and free. We're delighted that you're here. Gentleman is recognized.
Thank you, Mr. Chairman. I appreciate the lapel pin that you're wearing as well. But I want to thank you for allowing me and the ranking member Paulus for allowing me to present the case that I can bring my amendment to the House floor when the bill is considered. And there's no one there's no member in this Congress that is against manufacturing. We all want to see manufacturing. We all want to see jobs created in our nation. And I certainly appreciate Mr. Scalise's intention in promoting this bill and in authoring this bill. I think it's an important step. I do have concerns about unintended consequences of one particular paragraph in the bill, and I'd like to argue that I have an amendment that will improve that paragraph. Basically, my concern is that it will require the permitting, my amendment will allow the permitting authorities in the states to bypass Section 3B of the bill if it slows pre-construction permitting process times, if it increases air pollution that harms human health, if it increases regulatory uncertainty, if it shifts the burden of pollution control from new sources to existing sources, if it increases overall cost of attaining new air quality standards, or if it fosters additional litigation. Now, each state is the actual permitting authority in this situation, and I believe that the states should have the ability to opt out of Section 3B, which requires, as my good friend and colleague Mr. Whitfield just mentioned, it requires the EPA to issue statements, standards with regulatory guidance at the same time. So my fear, my concern is that would actually cause these problems which I've mentioned, and my amendment will give the states the ability to opt out of that section if they believe it's going to cause them additional costs. So I think that's the case that I'm going to try to make for your approval to bring my amendment to the floor. And I yield back.
Thank you very much. I want to thank both of you for being here. Mr. McNerney, can you give me an example, just one example, that the states would make an argument for that you're talking about?
Yes, Mr. Chairman. The California Air Resources Board, also known as the CARB, stated that the bill's provisions would result in delayed permit issuance and potentially pose public health risks. They also mentioned that for decades, the state permitting authorities have successfully implemented their programs in response to every new standard the EPA has promulgated. So I think there's, the state of Delaware also argued at the committee hearing that that this provision is going to increase regulatory uncertainty and will likely result in additional litigation, delays, additional costs, contrary to the original intent of the bill.
Mr. Whitfield?
Well, I appreciate the gentleman from California offering his amendment, and certainly if it goes to the floor, there will be a debate about it. But I would like to say that we've had a lot of hearings on this. The state of Colorado, the state of Arkansas, the National Association of Clean Air Agencies all came in and said this is a major impediment to their issuing these permits on a timely basis, because EPA is moving so quickly. They issue the final regulation, and then, as I said, they haven't provided the guidance and the regulatory certainty for the 2008 ambient air quality standards, the ozone standards. So all this legislation does is says when you issue the regulation, issue the guidance for clarity to remove uncertainties for the states and for the private industry applying for these permits.
Mr. Whitfield, is Mr. McNerney actually saying to me that, good gosh, if we had to produce sound science, we couldn't move as fast as what we wanted to? Is that what he's really saying to me? Because they're already delayed and not producing these things today, and yet the unintended consequence is, oh my gosh, if you make us apply sound science, it may take forever. Is that what I hear?
Well, I think so, but more important than that, his amendment will eliminate 3B, and B is the requirement that when you issue the regulation, you have to also have the guidance.
Right. Do I have this wrong?
Well, Mr. Chairman, the thing is that the states are the ones that issue these permits, and I think they should be given the flexibility to opt out if they believe that this requirement is going to increase costs or challenge the public health or put risk to pollution and public health. So I'm just trying to give something to give the states the flexibility to act in their own interest if they feel that this is going to be against their interests.
Ms. Whitfield, isn't this really asking the federal government at the time you promulgate a rule to have sound science and explain to people? And now
That's precisely what it is.
Okay, I
When
get
you
this
issue the
now.
new rule, have the guidance.
I get it. Okay. Yeah, awesome. Great. Thank you very much. Mr. Bishop? Gentleman has no questions. Gentlemen, the ranking member. Gentlemen, thank you very much for being here today. Hoorah for the United States Army. We really appreciate it. By the way, this guy right here is a member of the was a member of the United States Air Force who's on the front row, and big supporter of the men and women who protect this country. Thank you very much. Gentlemen, Mr. Polis is recognized.
Yeah, there are already enough loopholes in the Clean Air Act, and H.R. 4795 creates additional loopholes. Frankly, I think the American people want us to go the other direction. In the past few Congresses, I've introduced the BREATHE Act, H.R. 1154, which would close an exemption in the Clean Air Act for oil and gas producers. This legislation before us opens up additional loopholes, and I think that's the exact opposite of the way that we want to go to ensure that our air is clean. This particular piece of legislation creates a loophole that gives manufacturing facilities amnesty from our science-based air quality standards. And if the standards need to be changed, that would be the place to address it. But it wouldn't be to say, oh, it's a particular kind of activity, therefore we don't believe in our own standards. They should be agnostic with regard to what type of activity occurs. My question for Mr. McNerney is, maybe you can tell me about your background as a scientist and what your view scientifically of exempting certain activities from the Clean Air Act would be.
Thank you, Mr. Polis. I have a PhD in mathematics. I spent my career engineering wind turbines and the development of that and other energy-related issues. What I see here is that the EPA from time to time has to issue new regulations when new information comes in about the safety or about the pollution that may cause risk to public health. And it's important to issue those guidelines, it's important to issue those standards, but it takes time to develop the guidelines that industries may need in order to meet those standards. But the history is that the states have worked well with the EPA in developing those guidelines, and it hasn't resulted in delays. And in fact, with the California Air Resources Board, in my particular congressional district, my congressional district, the Regional Air Pollution Control District, has successfully addressed pre-construction permitting and has been able to process permits in just several hours. So I think we're not asking a whole lot here, but what my amendment does is actually gives states the flexibility in case they see problems with legal challenges or with delays or with additional costs. So basically what I want to do is give control back to the states so that they don't get hammered in by this sort of requirement.
Now, when we're talking about air quality and the objective science-based indicators of what's dangerous for human health and what's not, does the underlying activity that causes it matter, whether it's energy production or manufacturing or whatever else it might be?
Well, certainly if you're a person that gets cancer or asthma, then it doesn't matter to you much where it came from. What matters is your health, and so it's incumbent upon us to allow the EPA to promulgate standards when they realize there's a problem to protect human health. I think that ought to be our first priority. Now, history has shown that these changes in rules don't result in delays, and the way the bill is structured, there's going to be uncertainty as to who's going to have jurisdiction and when it's going to take place. So I think to give the states the option of opting out will actually be in the spirit of the original bill. So I would urge the members of the committee to support at least making the case on the House floor for the amendment.
Thank you. I urge the inclusion of Mr. McNerney's amendment, and I yield back.
Thank you very much. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. Mr. McNerney, I just wanted to ask, I don't want to get into the details. I'm not a scientist. I don't understand all the details. Rely on other folks to help me work through those. But Mr. Whitfield made the point that we've struggled with crafting the guidance for the ozone standards through 2009, through 2010, through 2011 and 12 and 13 and now 14, soon into 15, realizing that we may disagree about the details of how to fix it. Do we agree that that's no way to run a country? I mean, can we do better? Should we expect better? Or is that kind of uncertainty just what we have to live with in the 21st century?
Well, I think there's going to be, when a standard is realized and promulgated, there needs to be prompt action. The problem is that industry may not understand, and the regulators may not understand how to coordinate to address those new standards, and it takes time. And the states do cooperate with the EPA in understanding how to give guidance. So it takes time. Yes, I think 5 years seems excessive to me. I don't know the details of that case. It seems excessive, yes.
Mr. Whitfield, your amendment recognizes that some states might want to do things differently and allows for that. Is that the way I understand it?
Absolutely. They can have more stringent standards if they want to, under my amendment.
Your position is that the federal standard will be the floor, but anyone can go wherever they want to go from that federal floor?
And states can do that now, truthfully, but this is simply to clarify it because people have been making the argument that the Scalise bill would in effect prevent states from doing that. So this amendment simply clarifies that they can. But I would just reiterate once again that EPA, by not providing guidance, does create uncertainty, and it's not clear. So the state agencies and the applicants for these permits are not sure how to go about it. So as a result, the development of the manufacturing plants, the new plants, is slowed down. And when you have the economic stagnation that we have in this country, we don't think it's unreasonable to say to EPA, you've studied, you've come up with a new regulation, now also give us the guidance.
I hear two things from folks back home most often. One is, Rob, we can probably make anything work if you would just give us some certainty under which to work, and I appreciate your efforts in that direction. And secondly, they said, for Pete's sake, it just seems like you guys are arguing about things all the time. Isn't there a little give and take that can go on to make things happen? You heard folks express the concern about local governments and their freedom to act, and you're bringing forward an amendment to fix that concern, and I'm grateful to you for that. Thank you, Mr. McNerney. Mr. Chairman, I yield back.
Back to time. Gentleman from Massachusetts recognized.
Thank you, Mr. Chairman. I associate myself with the comments of Mr. Polis. I don't know if you've already submitted for the record the statement of administration policy on this, but if the President were presented with H.R. 4795, his senior advisors would recommend that he veto the bill. I don't think this is going to go anywhere, so it's not worth talking about much more. I think there are some other things that we ought to be doing right now, including debating a bill on whether we should, on authorizing the military action in Iraq right now, which doesn't seem to be on anybody's radar screen. But in any event, I ask unanimous consent to put that in the record.
Without
objection.
objection. Questions? Thank you very much. Gentleman yields back his time. Thank you very much. The gentleman from Texas is recognized. The gentleman from Texas is probably engaged in a lot of this theft of stealing jobs from across the country, Mr. Whitfield. And Mr. Burgess has seen his district grow. It's an enormous district over the last couple of years, and manufacturing is flocking to North Texas. So the gentleman, I'm sure, will have an opinion on this. Gentleman's recognized.
Well, yes, and I would like to make the observation, when I first arrived here well over 10 years ago, everyone decried the loss of manufacturing jobs in the United States of America. This was seen as a real problem. And it wasn't until I spent time on the Joint Economic Committee and heard testimony from the Department of Labor the first Friday of every month on the employment statistics, that I understood that Department of Labor includes in manufacturing those jobs that are produced in the energy industry. And of course, the Chairman is exactly correct. In North Texas, we have a significant amount of our employment that comes from people working in the energy industry, and as a consequence, in the recession of 2008, our area was probably a year behind the rest of the country in recognizing that there was, in fact, an economic downturn. Doesn't mean that it didn't eventually catch up with us. It did, reflected in real estate prices and other retail prices, but it was certainly startling to me to realize that because of the strength of our manufacturing sector, the effects of the economic downturn were significantly mitigated. So I really appreciate what you're trying to do here, which is to provide a little certainty to those people who are willing to make the investment, not of government money, but of their own money, private investment in the energy sector to provide the energy that is necessary to power this country and to power us out of the economic stagnation that you so aptly described. I do think the time involved in producing the regulations and the guidance that these companies are going to have to live under is it's taken far too long, and I really appreciate the gentleman's. I've been through, of course, a number of the hearings and markups with you in the Energy and Commerce Committee. This bill, which seems relatively straightforward, has been a long time in coming, and I really do appreciate you bringing it before us today.
Well, you've heard it from us. Ms. Minerni, do you have anything that you'd like to close with before we dismiss this panel?
Sure. Thank you, Mr. Chairman. I think the most important thing here is that if we go along with this without my amendment, what will happen is that the EPA will be forced to delay issuing standards on health, and it'll cost, as Mr. Polis pointed out, it'll cost people their health. It'll cost them their good health, cancers, asthma, and so on. So you don't want to delay the EPA issuing those standards, and if states are willing to work with the EPA to produce guidance without delaying manufacturing, then I don't think that's a problem. If they do think there's a problem that it'll affect their state's manufacturing base, then they can simply opt out according to my amendment. So it's fairly straightforward. It's really within the spirit of the original bill, and I ask the members to consider allowing me to move forward with this on the House floor.
Thank you very much. We're delighted that you're with us today. Mr. Chairman, thank you for taking time. Do you have anything, closing thoughts that you have for the committee?
No, thank you very much. I would just say in conclusion that we are here with this bill because we're hearing from manufacturers as well as from states that things are being delayed and we have a big backlog, and because we're not getting guidance from EPA. Thank you.
Well, thank you very much. I want to thank both of you for taking time. I don't believe, Mr. Chairman, you're going to stick around for the second panel, but I want to thank you. If y'all had anything in writing that you want to leave, please leave for their stenographer that is here, and I appreciate both of you being here, and thank you very much. The Chairman does not believe anyone else is here to testify for H.R. 4795, Promoting New Manufacturing Act, so we will now move on to H.R. 1422, EPA Science Advisory Board Reform Act, and H.R. 4012. I would ask to please come to the table three people. We have the Honorable Dave Schweikert, the gentleman who is the subcommittee chair on environment from the Commerce Science Committee on Science, Space, and Technology. We'd ask that he would please join us. The gentlewoman from Oregon, Ms. Bonamici, the ranking member on environment, and then our new young member who is real stalwart, the gentleman Chris Stewart, who is from the Appropriations Committee. And we're delighted that you're there. Chris, you're probably going to have to share with your neighbor over there that wonderful microphone, but trust me, she won't bite you. Awesome. So without objection, anything you have in writing will be entered in the record, and we would defer to the gentleman, Mr. Schweikert.
Thank you, Mr. Chairman and committee staff. I'm here on 4012. It's right now titled Secret Science Reform Act. I should share with you, if I was retitling it today, I would actually changed that. I would have changed it to something that I think it actually describes the underlying bill a little better. Public data for public policy by the data.
I'm sorry, I thought it... And to walk through some of the mechanics, transparency and reproducibility are basic tenets of science. Costly environmental regulations ultimately should be based on what's underlying in that data, but the public who is affected by such regulation should ultimately have access to this data. This Act will protect personal and confidential information. There's been a little noise in that, but the reality of it is every single day in this government, whether it be from the Census Bureau, CFPB, to FDA, we collect massive amounts of very personal data, and there's very simple statistical blinding methodology that's used all through government, and there's federal government policy in regards to such. In 2012, the President's scientific advisor testified, absolutely, the data on which regulatory decisions are based should be made available to the committee and should be made available to the public. Even the chair of the EPA's Science Advisory Board testified. EPA Advisory Board recommended that literature and data used by EPA be peer-reviewed and the data be made available to the public. Ultimately, this is a very simple concept, that if you're going to make public policy, that underlying data, not the models, not the decision, not the ultimate peer review of the peer review, but the underlying data sets. Because you have to accept we live in a world today where we're all walking around with phones that have computing power that was unimaginable 15, 20 years ago. Your ability to crunch math for whether it be a liberal group, conservative group, university group, academic group. There's one last thing I want to share, and this is, and I don't know if I'm going to hurt anyone's feelings on this. I don't think this bill leans either right or left. The fact of the matter is you could see a time when the underlying data sets are analyzed and matched up against other data sets and modeled, and you may find out that EPA is going the wrong direction. Heaven knows what direction that might be. But wouldn't it be nice to know that if we're going to make regulatory decisions, that it is based on an egalitarian access to that underlying data? And with that, I yield back, Mr. Chairman.
Thank you very much. Ms. Bonamici, I know you're here to speak about both bills. Would you prefer the gentleman from Utah speak first and then you talk about both, or would you like to talk about the bill H.R. 4012 first and then defer after Mr. Stewart does and make your comment?
Well, thank you very much, Mr. Chairman, for giving me that option. I would prefer to defer to Mr. Stewart, and then I have remarks that are about both of the bills.
That'd be awesome.
Thank you.
We're delighted that you're here. We want you to feel like you're right at home.
I do. Thank you.
Home field game, you're enjoying yourself. A gentleman
Between the two of us.
It's my
The
pleasure.
gentleman from Utah is now recognized for discussion that the gentleman may have on 1422. Gentleman's recognized.
Thank you, Mr. Chairman, and I must note you must be the most gracious chairman of all of Congress, so thank you for that. And I also can't help but note the very handsome lapel pin that you're wearing tonight.
Oh, now
Go-
you're
go
speaking
Air
about
Force.
my do you know why I wear this?
I could speculate, but
Because it fits one of my favorite sayings, peace through superior firepower.
that's
I believe this is how you get, this is an instrument of peace.
that's
I'm
a
for
theory I
peace.
concur with, Mr. Chairman,
Yes, sir.
so thank you. Thank you, and to the committee for consideration of my bill, H.R. 1422, the EPA Science Advisory Reform Act of 2013. I believe in general this is a common sense bill. I think it's a good government bill. It increases transparency, it increases public participation, and it leads to better counsel and better government. Specifically, the legislation addresses how the EPA is systematically silencing voices of dissent in the Science Advisory Board, ignoring calls for independence and ballots participation, and preventing the board from responding to congressional requests. Science is a valuable tool to help policymakers navigate complex issues, and the problem is when inconvenient science conclusions are disregarded or when dissenting voices are muzzled, a frank discussion becomes impossible. and government is ill-served when that is the case. The EPA Science Advisory Board Reform Act addresses these shortcomings by strengthening public participation, public comment opportunities, and improving the makeup of the Science Advisory Board and its subpanels. The bill reinforces peer review requirements and reduces conflicts of interest. It provides opportunities for dissenting panelists to make their views known, requires communication of uncertainties in scientific findings and conclusions, and limits non-scientific policy advice and recommendations while requiring explicit disclosure of such advice when the Science Advisory Board feels compelled to provide it. The Science Advisory Reform Act promotes fairness, transparency, and independence to ensure unbiased scientific advice. This legislation moves to the floor. We would ask the Rules Committee to issue a structured rule that makes my amendment and all other appropriate amendments in order. And if I could just quickly, Mr. Chairman, make a note on my amendment, the manager's amendment. It makes technical changes to conform with recent amendments to the underlying statute. I worked with Representative Davis to strengthen provisions he had worked to have successfully implemented in this year's Farm Bill. And finally, it also reiterates the independence of the Science Advisory Board and clarifies pre-existing language. It's very technical and not very substantive language. So with that, thank you, Mr. Chairman, and members of the board for considering H.R. 1422, and we look forward to discussing it with you.
Thank you very much, Mr. Stewart. Ms. Bonamici, welcome. We're delighted that you're here.
Thank you very much,
Chance to
Mr.
be
Chairman.
among two fine young men who I think spoke well, and we want to hear from you now.
Well, thank you very much, Mr. Chairman, and Mr. Polis and other members of the Rules Committee. I'm happy to be here today, and I want to say that have really enjoyed working with the current chairman of the Environment Subcommittee, Mr. Schweikert, and the former chairman of the Environment Subcommittee, Mr. Stewart. And I'm here today to testify about H.R. 1422, the EPA Science Advisory Board Reform Act, and H.R. 4012, the Secret Science Reform Act. Now, my colleagues on the committee have pursued these bills in the name of increasing transparency and improving the science that goes into EPA's regulations, and I applaud them for their efforts. Those are very laudable goals. Unfortunately, neither of these bills would succeed in constructively reforming EPA's processes for the better. Instead, they distort them in a way that will undermine the scientific integrity of the EPA's decision-making and unfortunately result in needless delays that could risk the health of American citizens and also threaten the environment. And unfortunately, unlike many of the bills that we have passed out of the Science Committee, these bills do not represent our best effort at bipartisan compromise. I have to say that I have really enjoyed working on the Science Committee on several pieces of bipartisan legislation. These two bills passed the Science Committee on party line votes. My Democratic colleagues and I have serious concerns about the consequences that these bills will have on the EPA's ability to protect public health and the environment. I'll start with H.R. 1422, the Science Advisory Board Reform Act, which would change the structure of the EPA Science Advisory Boards in a way that could undermine the credibility of the boards and also seriously delay their work. There have been several studies and reports, including several GAO reports, that have made reasonable and logical recommendations about how to improve science advisory boards. And unfortunately, those recommendations are not this bill. This act would allow a disproportionate number of members with industry interests to serve on the advisory board. And I don't object to having people with industry interests serving on the advisory boards. However, it would also reduce the number of our nation's top academic researchers. Regrettably, the act conflates bias with financial conflicts of interest. Board members may have bias. That's expert knowledge that orients them toward a particular scientific position. That's to be expected. But that's not the same as having a material interest in an outcome that could color their judgment and their actions. Bias is routinely identified and then balanced by including members who have different points of view. But you can't balance financial conflicts of interest, and they threaten the objectivity of the board and the integrity of science. H.R. 1422 goes against common practice, which is to manage conflict of interest through recusal or removal. and instead would allow board members with financial conflicts of interest as long as that interest is disclosed. At the same time, the Act makes it harder for the best and brightest from academia to serve because it would exclude anyone who has participated in activities that would even indirectly, that's directly or indirectly, reviewed by the EPA, which would disqualify some of the most qualified scientists. And those, Mr. Chairman and Rules Committee members, are the people we want on the advisory boards. Moreover, the bill adds burdensome and unnecessary requirements to the process, which could delay EPA actions to protect public health. For example, currently the science advisory boards are open to the public, they're open meetings, and they do have time for public comment. This bill adds an additional public comment procedure and also requires written response to substantial comments, which could delay, perhaps indefinitely, action. Although Democratic members had some of their amendments adopted during the committee consideration of the bill, the fundamental flaws of the bill remain. For that reason, I'm requesting an open rule to provide members with the opportunity to improve this legislation. And again, well-intentioned legislation, an open rule would help address some of these concerns and would improve the legislation. As I remarked, there are several reports making very valid recommendations about how we could improve the science advisory boards. Now I'd like to turn to H.R. 4012, the Secret Science Reform Act. Now, it appears that this bill is an attempt to limit the EPA because what's happened in the Science Committee is that the majority has sent a subpoena to the EPA, and through that subpoena they were not able to obtain the underlying information for some studies because it's personal health information, which the EPA could not turn over. The EPA was not able to provide personal health information. For one thing, it's not in their custody, contained in various independent studies. Now this bill seeks to prevent the EPA from using those studies and similar studies to support future regulatory action. H.R. 4012 would impede the EPA's ability to perform its most fundamental duty, protecting public health and the environment. H.R. 4012 prohibits the EPA from relying on the best and most relevant science as part of its rulemaking, and it does this by requiring that any data EPA considers while taking a regulatory action be made publicly available in a form that allows for substantial reproduction of research results. And that, Mr. Chairman and members, is specifically in the bill, publicly available in a manner that is sufficient for independent analysis and substantial reproduction of research results. That may sound like a reasonable requirement, but in reality, de-identified data, data that keeps medical information private, would not meet this threshold. Now, the EPA relies on thousands of epidemiological studies that contain personal health information. And I know Chairman Swikert from the Environment Subcommittee said we're not looking for that personal health information. But no legitimate researcher would break patient confidentiality. And so therefore, this bill would keep the best science from the EPA because it would not be capable of independent analysis and substantial reproduction of research results. Again, let me be clear, my colleagues and I support improving access to federally funded research. It's something that we've discussed in the committee, including data. But this bill does not do that. It has the potential to discourage people from participating in public health studies. It risks the well-being of the country in the process. So consider, for example, that the EPA would not be able to disseminate information on the risks of lead poisoning to children under this bill. It's no wonder that this bill is opposed by scores of research institutions and public health advocacy organizations, public policy watchdog groups, environmental groups, and many others. The list is long. Because of these concerns and more, I'm requesting an open rule on H.R. 4012 as well. And I know there are a couple of amendments that improve the bill, but they do not do enough to correct the significant flaws. I hope that every member has the opportunity to change this legislation for the better because, again, we are also interested in transparency and having data available, data that the EPA relies on, but under the way this bill is drafted, it would forbid the EPA from taking action on many, many important issues. Thank you very much, Mr. Chairman, for your consideration, and Rules Committee members. I'm happy to answer any questions you may have.
Thank you very much. Mr. Stewart, I want to be in reference to 1422. I note in the bill, and I want to thank you for this on page 5, it requires that any nominee shall file a written report disclosing financial relationships and interests, including Environmental Protection Agency grants, contracts, cooperation agreements, and other financial assistance. It also makes public specific dollar amounts for anyone that might have some sort of a conflict. I appreciate you doing this to make sure that transparency is achieved. Now, on page 7, it speaks about committees and investment panels, and it also talks about, in this, about the ability for minority reports to be published. Are they published today? Or why was this included in here?
Mr. Chairman, if I could address that, and I'd also like to make a comment on your previous statement, if I could, and that is that I don't believe, and we're not taking the position that everyone who has any financial involvement is necessarily conflicted by that. But this recognizes something that, this legislation recognizes something that I think is worth noting, and that is the advisory boards have, in my opinion, become significantly conflicted. 60% of current members have something approaching $140 million in direct government grants that they're involved with, that in many cases surely conflict them in their responsibility to provide unbiased opinion to the board. And this bill would help to, I think, if not eliminate that, at least shine sunlight on that so that other members and that the public would be more aware of that. And I'm sorry, Mr. Chairman, your second question was?
Well, second question is really very simple, and that is a minority report, or at the time that reports are issued, giving a dissenting view.
Well, that's right, and this allows for that vehicle, allows them a forum. No, sir, it's not.
Not included today. So if someone disagrees, you're not allowed to even provide information, for instance, about childhood diseases or about things which may be a problem. If you have a dissenting view, it's not published.
That's right, and there is almost always some dissent on these advisory panels, but no vehicle for them to present that dissent, which is one of the most meaningful reforms that's found in this legislation.
Well, I appreciate it. I think this is the part of the transparency that's been spoken to today about how what we're trying to do is make the board, not as Chairman Schweikert said, left or right, but really common sense, and I appreciate that common sense. Gentleman from Utah is recognized.
Let me just ask a couple of questions. How big is this board?
The law authorizes for 7, I believe, and it currently is constituted of 51 members.
51. And how many are representing the private sector industry?
Well, that depends on the subgroups, but very, very few. And one other thing that this board addresses is and encourages allowing members of state and local, and in some cases tribal entities to be members of the board as well. As an illustration of that, of the 51 members, only 2 of them represent state or local interests, both which happen to be California, which is a very powerful environmental entity already. But other than that, there's no state or local representatives on these boards.
How is the selection process made?
Well, they are, their names are put forward, and they go through a
By whom?
I believe that almost anyone could potentially nominate someone. There's a fairly open process for nominating someone to that. And I could, Mr. Bishop, I could check on that because I'm not certain on the details of the nominating process, but I believe it's fairly open.
And then who makes the selection process? Who makes the selections for the board?
I'm going to, before I answer that, I'm going to check and make sure. Yeah, it's only her, right? Yeah. And it is exclusively the administrator who selects members of the board.
From EPA?
Yes.
So, and you said in some of the reports you have shown, many reports have shown there are problems in this. Some are specifically talked about the CRS report specifically talked about the grant issue that you mentioned earlier.
Yes.
That has come out in other reports.
Yes, that's
Thank
true.
you. I have no more questions.
Gentlemen, I thank you very much. You know, It's not often you get a fellow member from Utah that shows up. He didn't need any help today, did he?
But when we do, they're damn good, aren't they?
They are darn good. Yes, sir, they are. And when you're from Utah, they're damn good. Thank you. Gentleman from Colorado's recognized.
Yeah, especially the retiree Mr. Matheson, who will be missed.
He will.
These bills, I have two statements of administrative policy, Mr. Chair, I'd like to submit to the record.
Without objection, they'll be entered in the record.
And without any great surprise, they both recommend that the President would veto these bills. So here we are with our precious little legislative time, last week here in November, perhaps a couple weeks in December, and rather than considering bills that have already passed the Senate and are sitting over here, like the Employment Non-Discrimination Act or immigration reform, or rather than working on bills that we hope to see through to a fruitful conclusion, we're looking at bills that the President would veto, just as we did with the Keystone bill, just as we're doing with these. So I question this use of time. It seems a little bit like spinning our wheels, and these bills in particular are both a thinly veiled attempt to tie the hands of the EPA and increase bureaucracy and red tape, hardly what we need to do to make government more responsive. I was hoping we could consider important bills that have passed the Senate, like immigration reform, or bipartisan efforts like tax reform that we might be able to get underway. My question for Ms. Bonamici is, can you talk about the ways that this bill increases bureaucracy and red tape?
Thank you, Mr. Polis. Both bills?
This is the 1422 bill.
The 1422?
The new advisory board, yeah.
Right.
new
Well,
members.
what would happen under the bill, and first I wanted to just respond briefly to the comment that was made about the minority reports. They can be appended to the report, so that I have that information to clarify the earlier question. One of the things that the bill does is that it does add a procedure. As I mentioned, currently the science advisory boards are open to the public and they have a period of time permitted for public comment. But under this particular bill, there will be an additional, it's called public information gathering session. And also, what happens in that information gathering session when people do make comments, under this bill, it states that the board's reports shall include written responses to significant comments offered by members of the public to the board. So it's adding an additional procedure. There does not appear to be any limit on the amount of information that come in, and it requires written responses. Now, I've tried to think of another instance where people, when the public writes written comments, for example, commenting on rulemaking, they don't expect or get a written response to every comment, but this would require that, so that could significantly increase, without additional funding, the work of the Science Advisory Board. And I also wanted to mention, too, that the comment that was made about financial conflicts of interest being disclosed. The issue is that currently financial conflicts of interest, or people with financial conflicts of interest, are either recused or removed. Under this bill, under the section that allows people with substantial and relevant experience not being excluded as long as they disclose their conflict. And that's a very different situation than the current, which requires them to either recuse or be removed. So I'm concerned about that, and also just wanted to respond to the section about the state, local, or tribal governments, which sounds like a good idea. However, this bill requires at least 10% of the membership be from state, local, or tribal governments, when the goal is to, in fact, have the people with the best and most relevant knowledge of the topic area, rather than have a percentage filled with state, local, or tribal governments, regardless of whether they are the best people for the positions. These are scientists or people with knowledge about the particular issues. So I just want to make sure that, although I wouldn't object to having people from state, local, or tribal governments if they're qualified, having a required ratio seems to be unnecessary. And again, I applaud my two colleagues I've enjoyed working with for the goals, but the way these bills are drafted, I'm concerned that they will require additional time and not actually do what they're intended to do.
Thank you. And I think that we'll probably be, I'm sure you will be reminding your colleagues of this, as will I, that for a bill to become law, the President does need to sign it. So, I mean, unless there's two-thirds support for some of these bills, which there wasn't for this Keystone bill, and we'll see if there are for these. It's just a exercise in futility here, where we talk about things, we pass things, but nothing ever becomes law. So if the interest is in actually passing laws, just keep in mind that it needs the President's pen to pass. We do have the Statement of Administrative Policy that the veto would be recommended for these. As Ms. Bonamici said, there's ample room to talk about reforming the advisory boards. I think Democrats are happy to have that discussion. But ultimately, there either needs to be a bill that the President would sign or a bill that would muster two-thirds support, including many Democrats here in this chamber as well. Happy to yield back.
Gentleman yields back his time. Thank you very much. The gentleman from Orlando, Florida is recognized. Gentleman does not seek time. Gentleman from Massachusetts.
And Mr. Schweiker and Mr. Stewart, do you favor an open rule for these bills?
I would actually,
Let me turn that on. One day I'll learn to turn the mic on, that a structured rule would be most appropriate.
I agree, we believe a structured rule is more appropriate for consideration.
And why? Is it, I mean, there's plenty, we're not doing anything, there's plenty of time. I mean,
Well, in our case, there have only been 2 amendments, they both were withdrawn.
So the Kennedy-McGovern-Clark amendment, are you fine with having that made in order for H.R. 4012, which would basically ensure that EPA is able to use all peer-reviewed scientific publications? Greater body of high-quality research will enable the EPA to make well-informed public policy decisions. Are you okay with that amendment being made in order? I'm not asking you to.
Mr. Chairman, Mr. McGovern, I think that may be on H.R. 4012.
Yes, I'm sorry. Yeah.
I actually look forward to the discussion and the debate on the floor on that one.
So you have no objection with that being made in order?
Happy to debate that on the floor because I think there's enough history and mechanics where it seems opposition on this piece of legislation changes with who's in the President in the Oval Office. Because part of this is previous legislation, conceptually from a decade ago, that data belongs to the public and anyone that's willing to work within that. And so I actually look forward to the debate on that.
Yeah, I mean, I'll just close by saying, it covers a process matter. We have now had the most closed rules in the history of any Congress. And that seems to run contrary to what all the promises were about. And and especially when we're not debating a lot of issues of that. I think that we have some urgent issues before us right now. With all due respect, I don't think this is the most urgent thing we should be doing right now, and nor do I think it's going to ever become law, at least not this year. I do think that you ought to give all members, an opportunity to be able to have their say on the House floor. And there are a lot of members who may not have filed amendments with the Rules Committee, who may decide on filing amendments after they listening to some of the debate, because quite frankly, a lot of people, I don't think, thought this was going to be what our main focus was going to be during the lame duck session. But I do think we ought to make all the amendments that are offered in order, but if, I think we ought to be all in a bipartisan way striving for a more open process. So, yeah.
Could I respond just briefly
Sure.
on that? I agree with you in principle that we would encourage that type of open and more agreeable debate, but in this case, the one amendment, the Democratic amendment, we've already accepted, so.
Yeah, well, as I said, I mean, we're all following this. I don't think most members thought that this is what we were going to be debating during this lame duck session. And I appreciate the fact that you're agreeable to a more open process, but quite frankly, we haven't seen it this year in this Congress. So maybe next Congress will be different. But I do think, as a matter of process and something like this, we don't have any other. We're not doing anything else. We might as well let people be able to debate whatever they want to debate. So, appreciate it.
Mr. Chairman and committee members, I I do agree that it's important to have an open rule on these. As you said, Mr. McGovern, people have been thinking about other things. It's been a busy time. They weren't expecting this to come up, and people have been gone. So just coming back today, I think it would be very helpful to have an open rule so that we can work to improve these pieces of legislation.
No, I thought when we came back during our lame duck session, we'd be debating, whether or not to authorize military action in Iraq. We all voted overwhelmingly in July saying that if we were to have sustained combat, we would have that debate and we would have that vote. We're putting more and more of our men and women in harm's way, and we're back and we're doing this and not doing that. And I just find that a little bit astonishing. But anyway, I appreciate your comments and look forward to tomorrow. I'll hold my breath.
Gentleman yields back his time. Does any other Republican have any request for time? Thank you very much. I appreciate the gentlewoman acknowledging not only that she's here, but ready to do some work, and thank you very much. Dr. Burgess, do you seek time?
Mr. Chairman, I'll have ample opportunity to speak on this tomorrow on the floor, on the rule, but I want to thank our witnesses for being here. I always learn so much by the quality of our witnesses seated at our witness table, and I'll yield back.
Indubitably. Gentleman yields back his time. I'm going to thank all three of you for taking time to be here for the time that you took. I noticed Mr. Schweiker brought his young wife by to see his outstanding performance that he would be making this evening. And Ms. Bonamici, I want to thank you. And Mr. Stewart, thank you for your service not only to people of Utah, but also the people of the nation for your service to the United States Air Force. I want to thank all three of you very much. Please do leave anything you have in writing for the gentlewoman so she can put it in the record. This now closes, and you're now excused, this now closes the hearing portion, seeing no further witnesses that seek time on H.R. 4795, H.R. 1422, H.R. 4012. The chairman will be in the receipt of a motion from the gentleman from Utah.
Where's Virginia when I need her? Mr. Chairman, I move the committee grant H.R. 1422, the EPA Science Advisory Board Reform Act of 2013, a structured rule. The rule provides 1 hour of debate equally divided and controlled by the chair and the ranking minority member of the Committee on Science, Space, and Technology. The rule waives all points of orders against consideration of the bill. The rule provides the amendment in the nature of a substitute recommended by the Committee on Science, Space, and Technology. Now printed, the bill should be considered as adopted, and the bill as amended should be considered as read. The rule waives all points of order against provision in the bill. As amended, the rule makes in order only the further amendment printed in Part A of the Rules Committee report if offered by Representative Stewart of Utah or his designee. That amendment shall be considered as read, shall be separately debatable for 10 minutes, equally divided, controlled by the proponent and opponent, shall not be subject to amendment, and shall not be subject to demand for division of the question. The rule waives all points of order against the amendment printed in Part A of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 4012, the Secret Science Reform Act of 2014, under a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Science, Space, and Technology. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, an amendment in the nature of substitute consisting of the text of the Rules Committee print 113-57 and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes in order only those further amendments printed in Part B of the Rules Committee report. Each such amendment shall be offered only in the order printed in the report, may be offered only by a member designated in the report, and shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by a proponent and opponent, shall not be subject to amendment, shall not be subject to demand for division of the question. The rule waives all points of order against the amendment printed in Part B of the report. The rule provides one motion to recommit with or without instructions. Section 3 of the rule provides for the consideration of H.R. 4795, the Promoting New Manufacturing Act, under a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of orders against consideration of the bill. The rule waives all points of order against the provision of the bill. The rule makes in order only those further amendments printed in Part C of the Rules Committee report Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in a report equally divided, controlled by a proponent and opponent, shall not be subject to amendment, shall not be subject to demand for division of the question. The rule waives all points of order against the amendment printed in Part C of the report. The rule provides one motion to recommit with or without instructions. Section 4 of the rule provides that on any legislative day during the period from November 21st, 2014 through November 28th, 2014, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and a time to be announced by the chair in declaration of the adjournment. Finally, Section 5 of the rule provides the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 4. So move.
You've not heard the gentleman from Utah. Motion has been made. I'd like to defer to the gentleman from Louisville, Texas, for any discussion about this. Gentleman's recognized.
Mr. Chairman, this rule provides for consideration of all three bills under a structured amendment process. For each bill, the rule makes in order all of the germane amendments currently before the committee. Lastly, it contains our normal floor management authority for the Thanksgiving district work period. This is a fair rule, and I urge its support and yield back.
You've now heard the motion and discussion from the gentleman from Utah and Texas. Is there any discussion or amendment? The gentleman from Colorado is recognized.
Thank you, Mr. Chairman. I have an amendment to the rule. I move the committee grant H.R. 4012, H.R. 1422, and H.R. 4795 open rules so that all members could have the opportunity to offer their amendments to these bills on the floor.
You now heard the gentleman from Colorado make a amendment for an open rules or further discussion. Those in favor of the Post Amendment signify by saying aye.
Aye.
Those opposed, no. The noes have it, noes have it. Further amendment or discussion? Seeing none, the vote will now be on the amendment, the motion from the gentleman from Utah, Mr. Bishop. Those in favor signify by saying aye. Aye. Those opposed, no.
No. No.
The ayes have it, the ayes have it.
Mr. Roll call, Mr. Chairman.
Gentleman asks for a roll call vote.
Ms. Fox? Aye. Ms. Fox? Aye. Mr. Bishop? Yay. Mr. Bishop? Aye. Mr. Cole? Mr. Woodall? Mr. Nugent? Mr. Webster? Mr. Webster? Aye. Ms. Ross-Lehtinen? Aye. Ms. Ross-Lehtinen? Aye. Mr. Burgess? Aye. Mr. Burgess? Aye. Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern? No. Mr. Hastings? Mr. Polis?
No.
Mr. Polis? No. Mr. Chairman?
I'd like to request if the gentleman from Oklahoma has recorded his vote first, please.
Mr. Cole is not recorded.
The gentleman will please ask the gentleman.
Mr. Cole? Aye. Mr. Cole? Aye.
Thank you
Mr.
very
Chairman?
much. Seeing no one else, I will vote aye.
Mr. Chairman? Aye.
Clerk will report the total.
7 yeas, 2 nays.
Motion is agreed to, motion is agreed to, and the gentleman from Texas, Dr. Burgess, will be handling this rule for Republicans.
And Mr. McGovern will be carrying the rule for the minority.
Mr. McGovern for the Democrats.
Short straw.
Thank you very much. I guess I'm happy to report that we will not have a further Rules Committee meeting that is scheduled for the week, allowing both sides the opportunity to go through their reorganizations and offering everybody a chance to be prepared for what will be what I believe is the real lame duck session as we get back and our performance teams are ready to go.
Mr. Chair, does that mean we're not scheduling the Don Sisson Memorial Meeting later this week?
Well, you know, there will be a lot of things that will probably be done. We've promised at least a dinner one night in his honor. So Louise and I have already publicly agreed to that you may be aware of.
Out of the majority's budget, I hope.
Well, it will not be out of anybody's budget that I know of, but I think Mrs. Slaughter and I agreed that we will do something here quickly.
If it is a complete stranger, I suggest we run it through the Ethics Committee to make sure that that's...
Well, in fact, I'll probably be paying for that otherwise, but it will be no stranger. It will be a good cheer and well received. Yeah, Uncle Pete. Uncle Pete will show up.
Thank you.
Yeah, you know him. A good uncle to have. Okay, anything further for Republicans? We're now done with our work for today. Thank you very much, and welcome back.